Good afternoon, everyone. My name is Kolvin Stone, and for those who don't know me, I'm a technology and a data lawyer and head the technology team at Fox Williams. Our seminar today is a part of our Disruptive Tech series. And when I started life as a lawyer 20 years ago, the maximum fine you could get for a privacy violation was £5,000. And for that to happen, the ICO had to issue an enforcement notice. And if you still didn't comply, the ICO would need to successfully prosecute you in county court. And after all of that process, the court could award a maximum fine of £5,000. So not surprisingly, there was little to no enforcement activity. And that was very much the case for a number of years. And that meant that businesses were not really taking privacy compliance seriously. I would regularly have conversations with clients who would balance the cost of compliance against the risks and costs of enforcement and conclude that it really wasn't worth spending the money on compliance. The conversation would regularly end with, so you are telling me the absolute worst case scenario is a £5,000 fine, and that's unlikely to happen. Okay, well, I'm not going to comply, at least for the time being. And that was the end of the conversation. How life has changed. And looking at the top 5 fines for GDPR violations, we currently have Amazon in number 1 spot with a eye-watering €746 million fine. Meta with a €405 million fine. Meta again with a €390 million fine. Meta again with a €265 million fine. And in 5th place, WhatsApp with a €225 million fine. So now the cost of compliance absolutely makes sense, and it is a priority at the highest levels of management. And that's not just because the risks and the costs are so high, but for many reasons. So, customer expectations, a stakeholder and individual activism are also key and important. So against this backdrop, we are fortunate today to have a panel of experts who will share their top tips for compliance and steering clear of trouble based on their own experiences of working in tech and data-driven businesses. So on our panel, we have Kristin Johnston. So Kristin is the Associate General Counsel for AI, Privacy and Security at Afiniti, which is one of the world's leading providers of AI solutions for improved customer service interactions. Then Nolan, who is Privacy Counsel at Revolut. Most people know Revolut, it's one of the fastest growing digital banks. And Dorota Kosela, who is the Global Head of Privacy at ComplyAdvantage, a leader in AI-driven fraud and AML risk detection. So for today's webinar, we'll follow a Q&A format, which is the format we normally use for these sessions. And so please feel free to ask any questions through the chat functionality, and I'll try as best I can to weave them into the conversation. So to our first question, I'm going to come to Kristin first. Kristin, what would you say is the single most important lesson you've learned or advice you have been given in your in-house legal and compliance role?
Thank you, Kolvin. Yeah, that's such a great question. I would say the single most important lesson that I've learned is that simplicity is genius. I really like a quote that I believe is attributed to Albert Einstein, which is, if you can't explain something simply, you don't understand it well enough. And when you think about your role as in-house privacy counsel, the business is in large part turning to you to help them understand what is arguably a complex regulatory landscape. You're in essence a business-friendly filter for legal complexity. You need to translate complicated requirements and simplify them as needed, depending on the business stakeholder that you're talking to within the company. And I can appreciate that companies are moving at the speed of light. So it's so critical to be able to drill down requirements and provide clear compliance guidance accordingly for the project or initiative that you're working on. And I'll note that I really like talking to in-house counsel at my company or talking to outside counsel about complex privacy rules and getting into the legal nuances. It's really fun and it's a great brain exercise. But whenever I'm speaking to the business and I need to carry certain information back to the business, I can't just, copy and paste, of course, that information back to the business. I need to make sure that I package it just the right way for the applicable business audience. So I would say simplicity is genius is one of the key pieces of advice that I've been given in my career.
Yeah, no, that resonates with me. One of my phrases when I'm talking to clients is to keep it stupid simple. What about you, Dorota? What would you say is the best piece of advice you've been given, or a lesson you've learned in your role?
All right. So yeah, simplicity is great. On top of simplicity, I would add understanding. Understand the legal environment your business is operating in, because that differs from pharma to fintech to finance. All companies operate in a certain context, and in that context, services and products are being provided. So to follow up on that, you need to understand the product very, very well. If it's a consumer product, download the product and use it, see how it works. If it's not a consumer product, ask for a test account to just see how it works on the back end, on the front end. Make sure that you understand what the product is doing with the data, because this is how you're going to be able to capture, for instance, all the data flow and understand what data is being collected, understand whether such a collection is necessary or not. And talk with the company, be active. Listen to what the colleagues are talking about, for instance. That's a great way of understanding what's happening in the company, internal discussions of other teams. So be there in the company and know the product from the up to the front, from the bottom to the top.
Okay, so really getting to know the business you're advising or the specific product or service that you're advising on, asking all those questions and really getting under the hood of exactly what's going on before you give your advice.
Yeah, that's exactly right.
Excellent. Ben, your thoughts?
Well, I've only been in-house for quite a short period of time now, so it's just past a year now. But I think probably the most important thing that I've learned so far is that it's not my job to accept risks on behalf of the business. I can give advice, I can advise on risks and help the business evaluate them. However, if the business wants to proceed in a way that's not compliant with my advice, then it's for the business to own the risk, the results from that.
Yeah, I understand that. And now I'm going to throw this out to all of you actually as a sort of follow-on question. When you're advising the business on risk, how do you help them properly understand that? Because we did a very interesting session with some lawyers from Facebook and Google a little while ago now, and they said exactly the same thing as Ben, but sometimes the business don't appreciate the risk. So the Facebook lawyer was saying, well, we didn't really appreciate, or the business didn't appreciate the risks around Cambridge Analytica, and then it blew up massively and was almost was a sort of bet the company situation for Facebook that they were able ultimately to navigate through. But how do you help your internal stakeholders actually understand and quantify that risk? And is there any situation where you have to say no or escalate it? And then how do you go about doing that? So maybe Kristin, you could maybe start with that.
Yeah, for sure. So I think it's important not just to talk through legal requirements, but also talk about explain, for example, the regulatory environment, for example, in terms of certain decisions, enforcement activity that is coming out. So, for example, in California late last year, the California Attorney General issued a particular enforcement action against a specific company that hit every single privacy blog. Everyone was talking about it. And I know a lot of privacy professionals were sharing that information with their business stakeholders to talk through it. And what are some takeaways, for example, for the business? And I think keeping privacy relevant and talking through the risks in light of the most recent enforcement activity, I think is really helpful. I think also, of course, talking through potential penalties for the applicable laws for your company. What happens if something breaks? What happens if something goes wrong? It's important to explain, given the applicable requirements, what are the potential penalties that would apply for the company. But I also think about it from a consumer trust perspective too. KPMG, I believe on a yearly basis, issues a consumer trust study or report, I think specifically on privacy. And it has a lot of great stats in terms of how consumers feel about privacy and why they believe privacy is important and why they prefer to give their data to companies that they trust. They believe that they have the right compliance policies and protocols in place. So I think speaking about the risk from both a regulatory perspective, but then also from a market consumer perspective is really helpful to put things in context.
Yeah, no, and I think because of all the recent enforcement action over the last few years, there are now situations where you can point to and say, well, actually, you can do this. This can possibly happen, and whereas actually that was much more difficult probably 10 years ago. Dorota, any thoughts?
Adding up, but I would also say customer expectations, which is especially important in B2B companies. Saying that, for instance, bad risk might, for instance, affect our contractual arrangements with the customers. So adding that to the ecosystem in which businesses are operating in, it's also shareholder expectations, for instance. It's also investor expectations, for instance, in many technology companies that have had investment. So it's good to put risk in context of expectations of all these stakeholders that actually might be affected when a certain decision is being made.
Yeah, I can see that might resonate with the business team more than some esoteric potential enforcement activity. Okay, so moving on. Our next question, Ben, I'll come to you first. So with limited resources, that's often the case for most businesses, and many competing priorities, and an increasingly risky regulatory and business environment, and customers are much more active, or users are much more active in terms of enforcing their rights. How do you prioritize as a team what to focus on?
It's a good question. Well, each quarter, we in the data protection legal team, we'll set roadmap items for ourselves that we as a team need to focus on. So typically these are areas where there are known gaps or known areas where we want to improve, or where we know that there's upcoming regulatory change. So for example, over the last few quarters, we had roadmap items relating to updating our agreements with vendors to include the new EU standard contractual clauses. So we aim for those roadmap items, and it will affect our performance if we don't hit them. So we've got quite a strong incentive to try and meet those items. In terms of the work that we carry out for other parts of the business, we use Jira, the project management software, to manage the work that comes to us, basically. So that means that anytime another part of the business wants to get advice from us, they need to raise a ticket in Jira. And when that happens, their ticket will be given a prioritization banding, basically. And that will be given based on the type of request the internal client's raising. So for example, if the query relates to credit, it might have a higher prioritization than a query relating to open banking. So, I mean, that tool is kind of useful in a sense because there are clear metrics for what should be prioritized, but that doesn't stop the business from telling you that everything's urgent. anyway.
Yeah.
But it helps to an extent.
No, it's that I have the same problem with clients. It's often who screams the loudest. But how do you set the priority then? So if you get a ticket that come in, how is it the privacy team that ultimately sets the priority, or is it informed by the business? How does that work?
So the prioritization bandings were set by the business rather
Right.
than the legal team. So there'll be
I think I lost Ben. So maybe Dorota, you could take the same question. So how do you internally sort of manage priorities? It's often a complaint of in-house lawyers and compliance professionals that can pulled in many different directions. How do you manage that?
So in terms of the work which is being assigned, it's more of discussing how short-term or long-term the work, like the perspective we are looking in. Sometimes it's just a quick review, which is an easy discussion and easy fix. And sometimes it's a part of a larger project. So the question is, how much does it affect the company overall in terms of significance, in terms of any potential regulatory exposure? So I would look at it as a way of seeing what the exposure risks, what the exposure is, what the risks are, and how much time will such a work take, and how many teams would it involve? Because some things can be fixed at a meeting and discussed. Sometimes it requires many meetings and a longer project to be rolled out in the company. So I guess it depends on the scale and the risks exposure.
Yeah. Krista?
Yeah, this is a great question as well. I found that partnership with key stakeholders across a business to be critical when identifying risks and what to prioritize. I found that best practice recommends that you have a risk-based or risk-driven compliance program, including, of course, your privacy program. And you're in essence prioritizing the highest risks for your organization and then taking steps to manage those risks in order of importance. And it's interesting, like you can know privacy law by heart, but you will not be able to identify privacy risks in a vacuum. You have to work with company stakeholders, and you need to talk with various team members across all levels of the organization. You need to make sure you're conducting your privacy impact assessments, your data protection impact assessments, your privacy risk assessments, and privacy program maturity assessments, and so on. There's so many different assessments that you can choose from to identify risks. And of course, you want to be mindful about which laws apply to your organization, and given your product and service offering, both current state as well as what's coming down the pipeline, it's important to think about the applicable risk assessment model or maturity model that you could use for your program. So I would say, for example, there's the NIST privacy framework that you could leverage. There's also the Association of Corporate Counsel. They published a few years ago a US-based maturity model that I know a lot of privacy professionals use, and they tailor it as needed for new laws, or they tailor it for their business. But the nice thing is there's a lot of different models, different assessments that you can leverage for your company and tailor accordingly for your business.
Yeah, I think what the theme that's coming out of that is it's a dialogue with internal stakeholders, and there needs to be a lot of action on the front end. Sounds like that's particularly the case with Ben in terms of agreeing what the priorities are, and then ultimately you can allocate certain tasks against that kind of set priority list. So it does the planning at the outset is obviously really key. So with tech companies, it's often the case they like to build and launch it at speed. It sort of used to be the case that you launch something and ask for forgiveness. I think that model is fortunately not so prevalent anymore. But I think compliance is still sometimes a little bit of an afterthought. Are there any tips that you can share that you've learned in terms of how you kind of manage that, how you kind of try and build compliance into the front end and the product development life cycle?
So I would say first that tone at the top is so critical and helpful. When your leadership emphasizes the importance of compliance and why it's so critical to meet business goals, you could leverage that messaging as needed for your day-to-day work. You can build it, for example, into your privacy compliance policy mission and vision, and make sure that stays top of mind, because having, of course, the backing of leadership for the work that you're doing from a privacy perspective, that's so important. The second item I would call out is that it's important to get involved in a project or an initiative as soon as possible. If you're involved at the end of the planning phase or post-launch, it's a lot tougher. You can still get the work done, but it's a lot tougher. The third item I would mention is that it's so important to be considered a close partner to the business. And you know you're doing things right when a team is launching a new project or initiative and they keep you top of mind for one of the critical attendees. I really like that. I know that I'm doing things right, especially when I'm new to an organization, when there's a new initiative starting and it's like, yes, we need to include Chris in XYZ meeting. So I really like that. And then the fourth item I would mention for this question is that I recommend providing information and training on privacy by design.
Right.
Which is, I think, helpful for team members to keep privacy top of mind towards the beginning of projects. So they understand that we need to embed privacy into the product, into the service offering early on to make sure things go according to plan.
So just coming back to that third item, and again, this is actually something that the lawyers from Facebook and Google emphasize is being a close partner to internal business teams, engineering and product in particular. How do you go about kind of building those relationships? Is there anything you can share that's worked for you and kind of really building that, that trust with those internal teams so they do get you involved?
Yeah,
Right at the
that's
outset?
Great question. I would say when you're new to an organization, that's such a great time to understand who are those key stakeholders in product. Let's say on the data team, like you just want to make sure that you talk through with your leader, for example, who should I be meeting with? Who would be, of course, close to the privacy program, who's involved in the overall corporate data ecosystem, and schedule those meetings early on, because if they know who you are and they know what you do and they know when to include you in certain meetings, that's really helpful. So building those relationships early on, especially if you're working remotely, which increasingly a lot of team members are, you want to get those calls scheduled and just a quick sync to introduce yourself, explain your subject matter expertise and how you can help the business, how you can partner with the business. And I think that's incredibly important, especially given the fact that compliance professionals and in-house counsel can often be seen as like the corporate police or like the in-house police, and they're there to say no to everything. So to present a smiling face and positive energy and say, I'm here to help you, I'm here to partner with you with your projects, that is so critical.
Ben, hopefully we can hear you now.
Can you hear me?
Yes, we can. Perfect.
Okay,
Good.
yes.
Welcome back.
Don't know what is going on today. But no, I fully agree with what Kristin said. I think when you deal with the business, they might initially suspect that you're out there just to block them, which is completely not the case. Like, we want to try and find solutions for the business to allow them what they want to do. So I think if you prove to the business that you are trying to find a route forward with them, that you're working hard to allow them to do what you want to do, that helps build up trust with them. And they see you not as a blocker, but someone that can actually help them design products that are actually better for their own customers. And then they appreciate that, and you might find that they keep coming back to you for more and more advice, which is something that I've found over the past year at Revolut.
Do you have a Revolut? Do you have a process that you follow when people want to launch products and services? We've had Tom, the general counsel at Revolut. He seems at the forefront of innovation in terms of building processes and kind of leveraging those.
Yeah.
You share what you do from a sort of process perspective?
Yeah, of course. I mean, like most things at Revolut, it's done over Jira. We've got really quite a well-defined product development process. So if an initiative, a new product, or a change to a product is risky from a data protection perspective, then it will go through an enhanced data protection review process before being launched. And the product team will basically need to work with us, take on board our advice, and implement any recommendations that we give to them before that they can go live with their product. So for example, if we say they need to do a DPIA before the product's launch, then they won't get our approval as part of the product development review process, and they won't actually be able to launch the product full stop. So we have quite a lot of leverage in that respect. So yeah, that's a sort of snapshot of it.
Dorota, just coming to you, just changing gears, slightly different topic. So I think one of the challenges of data privacy compliance is that once you've actually worked out what the rules are, which is not that easy, then ultimately how you're going to comply, you need to operationalize it. That can almost be the most challenging bit, particularly when you're trying to operationalize on a global basis, potentially across different products and services. So in your role as global head of privacy, can you share any of your best practices in terms of how you operationalize compliance, particularly on a cross-border basis?
Sure. So my approach would be to know the regulations which apply to the company I'm working at, and know which one provides this highest benchmark, provides the highest level of expectations towards companies that process personal data, be it in a controller or processor role. So setting up the most restrictive regulation that applies to us as this company, that would be the sort of a Northern Star in terms of our compliance, is very helpful. Until now, that was the reply was obvious that it would be the GDPR. Currently, it's more nuanced with all the new regulations springing up as they offer some differences. However, there would be this assumption that once a company complies with the GDPR, sets the processes and documentation aligned with the GDPR, then it should be assumed that it would be, to a great degree, compliant with all the other regulations, of course, with all these nuances which might be applicable. So yes, the first thing is to use the most restrictive applicable regulation as the benchmark. In terms of internal compliance, making sure whether we need a privacy team, is one person enough? Should we appoint a data protection officer, for instance? In some cases, it might be required under the GDPR. Some regulations just require that the DPO is appointed. So depending on where we are operating, where we have exposure, that might be the case. As we discussed earlier, it's crucial to know the product well. So that would also allow us to understand the data flows. And knowing the data flows allows us to cover the documentation for the data flows. For instance, in the European Union, transfer impact assessments are necessary in the UK as well. So make sure that all the transfers have been considered, have been thought about. Basically, being privacy compliant is also applying common sense, just to see whether we can explain what we are doing with the data. So yes, making sure that we have transfer impact assessment in place. Working closely with other teams, knowing where those teams are located, because that also affects the transfers. Working closely with other teams to establish processes internally, also to make sure that the processes are not duplicated. So if we are establishing a company-wide vendor assessment process to set up new suppliers, all the respective teams need to be included, just to make sure that we have one streamlined process and not 3 or 4 separate processes, for instance, by the engineers, by the security, by the legal. So yes, it's required just to make sure that each team knows what the other ones are doing, just to make sure that we are working on the same purpose. That requires meeting with the teams, discussing the new regulations, which might be applicable to the product, making sure that whatever new regulations are coming, we have a horizon and a timeline when they are applicable, because that gives us time to plan when to make any changes to the product. More and more regulations increasingly allow the consumers, for instance, to access their data. So it's a matter of rolling out, for instance, the data subject access rights programs that apply in Europe and in the UK, globally, elsewhere, because these are the regulatory requirements that are increasingly set up globally. Document the requirements. A lot of legal work, and probably the majority of legal work, is going through the documentation and making sure whether the contracts, whether the internal procedures, whether the internal policies are up to date, and whether new amendments or new documents have to be established. Just like Ben was saying a moment ago, standard contractual clauses. That's an enormous project which requires setting up timelines to make sure that they have been implemented on time. It's good to consider discuss implementing standards, ISO standards, for instance, or a Spanish privacy framework, because that gives a backbone to regulatory compliance, just to make sure that we have the documents in place and the procedures in place. Trainings are crucial. However, I've noticed that the understanding of privacy compliance has grown on the market significantly.
Right.
So it's a discussion like, to what degree do we want to be compliant? Do we want to be over the top? Because that can be the customer expectation as well. Or do we just want to meet a minimum standard? So the question is, how far do we want to go in making sure that we comply? Is it just the minimum base, or do we want to do everything even better than the regulations require? So trainings, making sure that whoever joins the company knows what the privacy requirements in the companies are. So they know that some things allowed, some things aren't, which is also currently increasingly significant with work from home, with employees moving around, for instance, with company equipment. So that has been a change in the last 2 years, which has significantly affected the work and the privacy flows. Review documentation and plan. Just make sure to have a plan for the next 12 months, for the next 6 months, to see what is happening and what regulations will be applicable and what changes have to be implemented in that case.
So you mentioned user rights. So individuals have certain rights, right to access their data, for example. And it sounds like you would take the view that maybe there's some jurisdictions that you operate in that don't have the same rights that we have in the UK and the EU, but you would apply those standards across those jurisdictions. Is that because you think it's the right thing to do in terms of individuals, because you don't want to differentiate between the individuals, or is it because it's just much easier to operationalize? So you meet the higher standard. What's the sort of driving? What's the main kind of rationale for that? Is it sort of the user goodwill and user experience, or is it just that it's easier to operationalize compliance in that regard? Everyone just follows the same standard.
I think it depends on the company basis and on the product they offer and how much data hungry they are, how much data they need to further develop the product, for instance. So for some companies, deleting some data would be more like painful in terms of product development for the others. So I think that should be in the center of a discussion, whether the privacy program allowing the users to delete their data should be applied, rolled out globally in the same way, or whether it should also be, or whether it should only be applicable to the regulations that require such data deletion, data access. I think from the operational point of view, it's easier to only review those requests from jurisdictions that require for such processes to be in place, because usually in smaller companies that process can be made manually. However, when there are where this process is more streamlined, when there is a software, for instance, to handle such requests, it is worth discussing whether all the requests should be treated as equal, regardless of the jurisdiction they come from, or whether we still should be picking out depending on the regulation, on the jurisdiction they come from. So I think it depends on the company and the need for the data in that company, whether they need it or whether it's not necessary.
Yeah, and I mean, certainly some of the conversations that I have with on the B2C organizations, their rationale for treating everyone the same is that they don't want to differentiate between their customers and offer less rights in this country as compared to this country, because it's poor from a sort of customer relationship perspective. Kristin, what do you think about that?
Yeah, I've had so many conversations on this topic over the past several years. And yeah, it's very company specific and how the company wants to implement these requirements. Because to that point, Kolvin, in terms of how would the customer feel from a B2C perspective, I've had those conversations in terms of like, well, how would the consumer feel if they know that if they're not in a specific jurisdiction, they're not afforded certain rights? And we want to make sure that, people feel like, and they understand that we take privacy seriously, that kind of thing. So, so many companies have these conversations, and it really comes down to, of course, the requirements, but then how does the company want to operationalize these requirements, the applicable ones, and then also from a consumer treatment perspective, how does the company want to implement these requirements, keeping the consumer top of mind? So I can appreciate, like, especially given conversations I've had in my network and so forth, how involved that conversation is. But there's also that operational impact that was already discussed. Like, how do you actually implement, how do you execute the consumer rights function on the back end? And if you don't have a tool, for example, and there's so many different privacy, governance, risk, and compliance tools that you can leverage to facilitate handling these consumer requests. But if you're doing this manually, that directly impacts how, the decision in terms of how do you want to move forward with this? What's the most efficient way to do this? Most streamlined way to do this while keeping the laws top of mind.
No, that makes sense. I mean, if you can automate it, it kind of makes sense to roll it out globally. But if you're doing it on a manual basis, that's going to create a lot of work, I think.
Oh, yeah.
Okay, so just moving on to the next topic. I think one of the issues with being, a privacy law is this sort of constant change, both from a legal perspective, a regulatory perspective. So every day it feels like there's a new law or a landmark case or a huge fine. Ben, from your perspective, are there any hacks that you can share that you use to kind of keep abreast of what's going on and the latest developments?
Yeah, nothing particularly innovative, to be perfectly honest. I subscribe to Lexology, and you set the fields that you're interested in. So I receive updates every morning from Lexology, and I try and set aside 10-15 minutes each morning just to sift through the articles, see if there's anything either interesting. It doesn't have to necessarily be a brand new development. If there's an article that's interesting about something that's been around for a while, I'll still have a read of it. But if there have been developments, then there's bound to be many law firms that will have written an article about it. So I'll have a flick through that. And then if it's something that's actually, really quite important to the business, then I'll try and read the actual guidance from the regulator or a case, rather than just relying on the law firm's work. Aside from that, a good resource I find is also LinkedIn. So just following, prominent partners in the data protection space, such as yourself. So I get updates from you and various other data protection partners at London law firms. So that's how I keep up with developments.
Yeah, so I think that's like carving out part of your day in order to invest in your knowledge. I think it's good, and it's easy not to do it. But I think being disciplined about it is a good thing. Kristin, anything that you do?
Yeah, definitely. So there's so many resources out there, Thomson Reuters products like Practical Law and Westlaw. There's also, of course, the International Association of Privacy Professionals. They provide so many excellent resources and updates on their website. And then there are also update feeds, I believe, through privacy compliance platforms like TrustArc and OneTrust. So you can get a feed through there. You can follow, of course, law firm blogs, subscribe to different regulator feeds. But LinkedIn, I will definitely call out as well. In addition to Ben, LinkedIn is amazing. And I've had conversations over the past few years about it. And people will say like, oh, isn't LinkedIn, especially other attorneys, they'll say, oh, I thought LinkedIn was just for like searching for a job or recruiters and so forth. It's like, actually, no, like when I'm on LinkedIn looking at the latest and greatest privacy updates and responsible AI updates. And one of the things that I found to be beneficial is, given who I'm connected to, who I have followed, given the gazillion hashtags that I have intentionally followed as well, my feed is so perfectly curated to track developments across multiple jurisdictions simultaneously. And I knew my feed was curated well when all of a sudden an update would come out, a new case decision, a new regulation, and several people in the privacy world were talking about it simultaneously. And I'm like, yep, right, this algorithm is working in my favor. So like, it's really good to leverage LinkedIn because it's kind of like pulling from different feeds, different sources, and putting it all in one helpful place. And I find that to be super helpful to track on a day-to-day basis.
So that's what, using the hashtags specifically.
Hashtags, and also following certain people. Yeah. So if I'm not connected to them directly, then I'll follow them. But what I have found to be helpful is when someone that I'm connected to or someone that I'm following likes a certain post, right, I'll check out that person's profile, follow them, and also check for certain hashtags. And when you click on a hashtag, you can see how many people are following them. And depending on how popular they are, those hashtags, I'll follow those as well. And so my feed is so perfectly curated to track certain developments, given who I'm following, what hashtags I'm following, that kind of thing, for both privacy and also responsible AI.
Right. Yeah, that I think I agree. LinkedIn is a great resource, and I think it's been sort of supercharged in during COVID and a post-COVID world, where so much activity shifted online. Dorota, anything you want to add in terms of hacks that you use to keep you on top of what's going on?
Yeah, like I use LinkedIn and IAPP's baby bulletins, but what Kristin said was like very impressive. So I'm going to try it out as we finish our discussion. I do find that it's not only law firm partners that publish interesting content, but also there is a lot of independent privacy consultants who want to be shown out with the word, and they offer very, very interesting insights sometimes. So the privacy ecosystem and the advisors it's just getting more varied, it's getting more interesting, and they are all publishing. So there's tons of interesting content. And yes, LinkedIn is the number one for me to go.
Yeah, the ecosystem is now, it's huge, and that's very helpful for us as practitioners in that field. So one of the good things I think about privacy compliance is I think it's a team sport, and we've been highlighting that in the context of how you engage with internal stakeholders. But what about when you need to bring help from outside? So either it be in the form of a outside counsel, a law firm, or maybe some consultants. A lot of people used consultants during the crazy time of GDPR compliance, because sometimes you do need people. You might need specific expertise, or you might need a big project that you require help implementing. Any kind of best practices that you can share, and I'll come to you first, Kristin, in terms of how to get the best out of outside counsel, or any external consultants you use them, or when to use them and when not to use them. Anything you can share around that?
Yeah, definitely. So I've found outside counsel to be excellent partners with thinking through how to strategically operationalize a particular requirement, especially when you think about the new requirements as they come out, and really thinking through, okay, here's this new law, here's this new requirement. What's the best way to embed this within the business? And I think playing the role of in-house counsel, it's so important of course, for you to take those conversations with your business partners, the facts, the information about the project, the data ecosystem associated with a particular initiative, and bring that to your conversations with outside counsel so you can really have an informed conversation and strategizing session as to the best way to execute something. And then you can take certain information, of course, back to the business. And I think that what's really cool about outside counsel too is that you can benefit from their experience working with similar clients and how other clients are operationalizing requirements. I think that's great. And then, of course, outside counsel, just like in-house counsel, they're tracking all of these regulatory developments, for example, in privacy, in responsible AI. And so you can, check in with them for their thoughts as new developments are coming out, and think through how to pull these requirements into your existing program. So I think outside counsel are excellent partners for any compliance program.
Dorota?
Right. So yeah, outside counsel are great. Also, just to bounce off an idea to see how they see it, because they might have also more cross industry, more international context of knowing how the topic is going to be assessed by potential regulators. When using outside counsel and looking for a new outside counsel in a jurisdiction, I rely on recommendation. Just see whether anyone I know in that jurisdiction has used an outside counsel and who would they recommend. Yes, LinkedIn, in terms of seeing the content that they produce, is also very important, just to get to know them better before engaging such an outside counsel. I think that what I expect from outside counsel I'm working with is just not to provide this bit of advice for now and here, but also be able to put it in this more context of how this is going to play out for the business later. Like knowing where we operate, knowing what issues we might come across with such an issue in a different jurisdiction, just to be able to do this forward thinking as well with us.
Yeah, so do you see outside counsel as more kind of strategic partners? Is that generally how you tend to use them, would you say? Is that more the role you see?
I think both. It's sometimes an ad hoc question, let's discuss something, how do you feel about it? But in terms of working on a strategy, they can also be extremely helpful. Also because they've seen a lot of similar questions.
Yeah,
but true. Probably not now with all the new regulations developing, but they probably can also use their experience from similar projects.
Yeah. Great. Okay, so we've got a few minutes left. So last kind of two topics I kind of wanted to explore was Ben, I'll start with you. Are there any legal tech, or you mentioned a couple in terms of project management, Jira, but are there any other kind of legal tech or compliance products that you think are helpful in your role, but other people might also find helpful?
It's not necessarily legal tech again, so I may be going off on a bit of a tangent here, but I really like Figma, which is the product design software. I find it really helpful to visualize customer journeys, and you can include comments where we might need to include some privacy wording. So I find that really, really helpful in terms of visualizing the products that we'll be coming out with. So yeah, I would say that's my favorite software that I've been using since I moved in-house.
And so how do you use that, Ben?
So it's basically, it shows you what the app will look like. So what each screen of a user journey would look like.
Right.
So you've got the entry point, and then each screen that the customer will need to click through before they can sign up for a product.
Right.
We've been using it a lot. We've been releasing credit products in quite a few different countries lately. So it's been really helpful to visualize those user journeys and set out where we need to notify customers that credit checks will be carried out, for example. And you can include comments at various parts of the flow so the team know exactly where they need to make the change that you've asked them to make.
Okay, yeah. So it helps so when you're doing a product review, it helps visualize the user journey, basically.
Exactly, yeah.
Excellent. Okay. Kristin, anything that
Yeah.
that you can share?
Definitely. So I've used a number of tools across the course of my career, including but not limited to TrustArc, OneTrust. I've also leveraged ServiceNow, Smartsheet, Atlassian tools, like Ben mentioned, Jira, Confluence, Trello, and several others. And so some of these tools are specific to privacy, and some are tools that you can use for so many different things, but you can tailor it as needed for your privacy compliance program. But you also want to be mindful about how you're using these tools. So you want to be mindful about who has access to certain information when you're putting certain info in there. You want to be mindful about attorney-client privilege considerations and so forth. But if you're using the tools the right way, you can really find benefit from moving away from more manual processes with your privacy compliance program and automating certain elements of the program, as well as getting some fancy dashboards and reporting, immediate risk analysis, that kind of thing. So I found those to be beneficial, especially if you're working across several jurisdictions. If you're a global company, using those tools, I think, is like an absolute must if you can do it. And then also I recommend, it's like, depending on which company you work for and what makes the most sense, I recommend setting up demo sessions with different vendors to see what makes the most sense. Because I may have a favorite, but that favorite may or may not work for you. So those demo sessions, I think, are so critical.
Yeah, that makes sense. And so, I do remember doing those manual reviews when, rather than having the, an app where you can visualize the user journey, I think we would print off screenshots, mark it up and scan it and send it back to the client. So, Dorota, is there anything that you could recommend from a kind of tools perspective?
Yeah, so we are also using Atlassian, Jira. I had experience with Confluence. I tried OneTrust to see how it would play out. It's a very interesting tool as well. So CIPP has this section of vendors, privacy vendors, and it's actually very helpful to go to their website and see what vendors they present. And some of those vendors also have trial tools. So that is a great resource for anyone who is to see what the market for privacy vendors look like. So the CIPP website.
Yeah, I mean, it's such an incredible resource, the CIPP, and also in the context of LinkedIn, they run a lot of sessions that they broadcast live on LinkedIn as well. So they're also using that platform really well. So looking to the future, what do you see as the biggest single development that is going to impact on your role this year? So I'm thinking kind of legal and privacy specific. But Ben, you could start first.
Yeah, I mean, I think the EU's AI Act and e-privacy regulation, whenever they come into effect, will be massive for Revolut, whenever that may be. But in terms of the next year, I think probably the most impactful development from a privacy perspective will be the proposed adequacy decision in respect of the US. I hope it will make our lives a lot easier if it's ever granted properly. So I kind of hope that that's the biggest development for us in the next year.
Yeah, well, there's sort of UK and EU. I'm sure the UK are desperately trying to hit the EU to the post in terms of getting that set up first. Dorota, what about you? So, what do you think is the sort of the biggest single development that will impact your role this year?
So yes, I'm looking closely at the AI Act. I'm looking at what's happening in the UK with the planned diversions from the GDPR. Well, it's difficult to speak out one act. Probably I'm watching also the US very closely, and it's going to affect my role in terms of any new legal regulations applicable in the US states. So I am following closely the developments there because they are going to affect my work.
Kristin?
Yeah, I would say, of course, definitely from a privacy perspective, we have 5 privacy laws going into effect in the US this year. So that's definitely a huge development. But working for an AI company, I would say the biggest development is, of course, what's happening in the EU. And I also know that per the Organization for Economic Cooperation and Development, they're tracking over 800 AI policy initiatives from 69 countries, territories, and the EU. So if you're working in AI or you are using any tools that involve AI, this directly impacts you as well. So I think we're collectively, of course, watching what's happening from that perspective. And when you think about what's happening with generative AI tools like ChatGPT, like everyone's talking about that. So I think AI is going to be like the hot topic for 2023 and will pretty much impact everyone.
No, I agree. And it pretty much impacts every technology company to a lesser or greater degree. Because I think not many technology companies that don't use AI in some shape or form. We've got a couple of minutes left. I've got a question from the audience, not the easiest question to answer, but I will pose it and see who wants to answer it. And if you do want to pose a question, now's the time to do it. We've only got a couple of minutes left, but we've had this question in, and I'll just read it. How do clients typically manage the interaction between GDPR compliance and the duty to preserve all data during litigation? Do they take a view that holding on to large swaths of data, even if for a new purpose of litigation, is a disproportionate risk given the repercussions of security breaches? So it's this balance between preserving data for litigation and then the requirement under the GDPR around storage limitation and data minimization, and your obligation to delete data if you no longer need it. So is there a volunteer to answer that question?
Yeah, I can speak high level to it.
Yeah.
Not in the weeds from like an implementation standpoint, but I would say that's why it's so important to have a record retention policy, a documented record retention policy that includes a section or protocols about legal holds. And so if there's any litigation, a certain data needs to be preserved, like what does that mean from a legal requirement perspective? But then also, how do you actually execute that? And of course, the devil is in the details, but having that is such, a great question. And that's why you need to have a documented policy that speaks to that, striking that balancing act between data minimization, having a record retention policy, but then making sure that you're abiding by the right requirements from a legal hold perspective. So that policy is so critical. That's super high level, but I think that's a key step.
No, I absolutely agree. I think that's ultimately it, is going through the process of defining how long you need to keep data in terms of your business need, documenting that. And ultimately, when there is litigation, having a process that is in place where you preserve records, data, and evidence for litigation purposes, and that should all be subject to litigation hold. Okay, well, look, I'm going to finish there because we're pretty much at time for the end of the webinar. So all that remains is to thank the panel and say thank you so much for such an informative and interesting discussion. I hope you all enjoyed it, and thank you so much for attending, and enjoy the rest of the day. Thank you very much, everyone. Goodbye.
Thank you.
Thank you. Thanks. Bye.